Greetings, Twitter. X. I'm going to try this for the third time. I did the live stream moments ago, and for some reason, it crapped out right at the very end. And I was thinking, should I redo it? Should I not? And I've decided to go ahead and try for a third time to get my entire thoughts into the stream. So this may sound a little redundant if you're tuning in and you tuned into the previous stream. The reason that I'm redoing it is because I lost the last couple of minutes of live stream. I kept on talking, and I didn't realize that the stream had ended abruptly. My apologies. And as I said previously, my original intent was to go live on Saturday and talk about the abortion lawsuit that went before the Texas State Supreme Court. They had a hearing, and I had a chance to watch it. I was going to talk about it and everything, but unfortunately, for reasons beyond my control, I had something come up over the weekend, and I was not able to go live on Saturday as I wanted to, and my intent was to go live at the beginning of this week, but getting home late from work and other things going on, I did not have the ample time to set up and do the live stream like I wanted to. And I think it was a mixed blessing because in the process I learned of a second emergency lawsuit that was filed. I think it was Tuesday, and they had the emergency hearing on it this morning in Austin, I believe it was, or in Dallas. I don't remember where it was. And I wanted to watch the hearing, and I wanted to comment on it and whatnot, but I didn't have a chance to. Shortly thereafter, the state attorney general issued a letter to the hospitals that the doctor in question on this emergency lawsuit has this holding privileges. And I found it kind of concerning when he issued the letter, because you would think he would have issued it. See, the whole thing is this: the state attorney general and the Texas Medical Board have been hush. They've been silent on clarifications about the medical exception that's built into these abortion laws. Doctors, patients alike, pregnant women, have all wanted clarification as to what the medical exception says. And unfortunately, the district attorney, the attorney general of the state of Texas, the Texas Medical Board have all been silent on this. They've been, mum. They refused to give clarification, and that's what generated all these lawsuits that have occurred. Well, suffice it to say, with the emergency lawsuit, he responded to the hospitals, and I wanted to read this letter and talk about this because I believe it's concerning, and I believe that to a certain degree there may have been some malicious intent with respect to the letter, and I wanted to touch base on that. But I wanted to read the letter to you, read portions of the letter to you so you could hear word for word what the Attorney General is saying with respect to the medical exception. I'm going to pull up the press release that he put on his Twitter. I'm going to blow it up and see. This is the statement. Basically, I'm going to read it off the screen. He says, the temporary restraining order, TRO, granted by the Travis County District Judge purporting to allow an abortion to proceed will not insulate hospitals, doctors, or anyone else from civil and criminal liability for violating Texas abortion laws. This includes first-degree felony prosecutions And he talks about the statutes and the penalties of $100,000 for each violation. He says, and while the TRO purports to temporarily enjoin actions tonight, brought by the OAG and Texas Medical Board against Dr. Curran and her staff, it does not enjoin actions brought by private citizens, nor does it prohibit a district or county attorney from enforcing Texas pre-rule abortion laws against Dr. Carson or anyone else. The TRO will expire long before the statute of limitations for violating Texas abortion laws expires. So that the statement that he's making. Now let's look at the letter that he is. Give me a second. Hold on. I'm going to pull up the letter. Hold on. I'm having issues with my computer here. Okay, there we go. I got it. Now let's bring it up. And then pull it up full screen. This is the first page of the letter that was sent to the 3 hospitals where this doctor has holding privileges. And I'm going to read this to you. The first paragraph, it says, it's come to our attention that Damla Carson, MD, a physician holding privileges at your hospital, intends to perform a dilation, evacuation, abortion on Ms. Kate Cox. Today, an activist Travis County judge, he calls the judge an activist, believe it or not, signed a temporary restraining order, TRO, purporting to enjoin the Attorney General's office and the Texas Medical Board from enforcing some of the state's abortion laws against Dr. Carson if she performs an abortion on Ms. Cox. We feel it's important for you to understand the potential long-term implications if you permit such an abortion to occur at your facility. It says, first, the TRO will not insulate you or anyone else from civil and criminal liability for violating Texas abortion laws, including first-degree felony prosecutions. So he talks about that, and let me go to the next page. And this is the next page. So let me pull it up full screen. And this is what he says here at the top of the next page. It continues the paragraph saying, so talk about the civil penalties of not less than $100,000 per each violation. He says, and while the TRO, the restraining order, purports to temporarily enjoin act by the OAG, which is Office of Attorney General, and TMB, against Dr. Carson and her staff, does not enjoin actions brought by private citizens. Nor does it prohibit a district or county attorney from enforcing Texas pre-rule abortion laws against you, Dr. Carson, or anyone else. We remind you the TRO will expire long before the statute of limitations for violating Texas abortion laws expires. Second, it is the hospitals, not the courts, that have the training, responsibility, and discretion to determine in accordance with state law and with the advice of medical staff which categories of practitioners are eligible for candidates for appointment to medical staff. He's talking about hiring practices. He says your hospital may be liable for negligently credentialing the physician and failing to exercise appropriate professional judgment, among other potential regulatory and civil violations, if you permit Dr. Carson to perform an unlawful abortion. He said, third, it appears that Dr. Carson failed to follow your hospital's procedures for determining whether Ms. Cox qualifies for the medical exception to Texas abortion laws. It appears she has not sought a second opinion from a colleague at your hospital to determine whether they agree with her that Ms. Cox qualifies for the medical exception. Nothing in the TRO compels you to waive your hospital's long-standing policies for determining whether a patient, including Ms. Cox, qualifies for the medical exception to Texas abortion laws. Fourth, he says the TRO and the allegations in this lawsuit on their face fail to establish that Ms. Cox qualifies for the medical exception to Texas abortion laws. Now, here's the clarification that everybody's been waiting for. It says, to fall within the medical exception, the physician must determine in the exercise of reasonable medical judgment that the pregnant female on whom the abortion performed, induced, or attempted has a life-threatening physical condition aggravated by or caused by or arising from a pregnancy that places the female at risk of death or poses a serious risk of substantial impairment of a major bodily function unless the abortion is performed or induced. He says the TRO states that Dr. Carson believes in good faith that the abortion is medically recommended for Ms. Cox, but that is not the legal standard. Reasonable medical judgment and a life-threatening physical condition are. There's the catch. It says reasonable medical judgment and a life-threatening physical condition. All right. The TRO is further deficient because it fails to identify what life-threatening medical condition that Ms. Cox purportedly has that is aggravated by, caused by, or arising from a pregnancy, nor does it state with specificity how this unidentified condition places Ms. Cox at risk of death or poses a serious risk of substantial impairment of a major bodily function unless the abortion is performed or induced. The temporary ruling fails to show that Dr. Carson meets all the elements necessary to fall within the exception to Texas abortion laws. His Judge Garrett Campbell is not medically qualified to make this determination and should not be relied upon. A TRO is no substitute for medical judgment. That's the whatchamadoodle, or the letter in a nutshell, basically. Now, upon reading this letter, there's a couple of things that catch my eye that make me think that there's some sort of malicious intent behind it, and I'm going to point those out. The first one is the fact that the Attorney General calls the judge an activist. When you're writing this type of letter to an organization to advise them of the possible criminal liability that they would have, you don't go bad-mouthing a judicial official. It kind of gives a negative connotation to a letter. It's not something that is ethically correct, mind you. The second thing is that he says at the end of that second paragraph, we remind you that the TRO will expire long before the statute of limitations for violating Texas abortion laws expires. This leads me to believe, number one, that Ken Paxton knows he can't touch the doctor or the patient because of the TRO. So what he is doing, in essence, is he is circumventing the TRO and attempting to basically prosecute these three hospitals right here, these three hospitals, into calling off the abortion because he says, okay, you will be held liable if the abortion occurs because the TRO does not cover you. Now, I haven't read the TRO yet. The Center for Reproductive Rights says that Paxton is misrepresenting it. I don't know. I have yet to read it. I will read it, and I will come back later and give my comments with respect to the TRO and the letter. But I believe that those two points in the letter lead me to believe that there is some sort of malicious intent. I may be wrong because of the way he wrote it. He says that the hospitals and the doctors have the responsibility, in accordance with state law, to determine who the eligible counts, who are the eligible people that fall under the medical exception. Now, the important thing is in the last paragraph, he clarifies what the medical exception is. And basically what he's saying is that he says two things. that the physician must exercise reasonable medical judgment, and